Welcome to Cooper Union. My name is Jamshed Barucha, and I am the president of Cooper Union. And it is my distinct pleasure to introduce this lecture series. Cooper Union has a long tradition of public lectures for the community, the tradition going back to the founder of the Cooper Union, Peter Cooper himself, who in 1859, when he opened this institution and this great hall, wanted New York to have a hall which would be the center of the free expression of ideas in the democracy, which at that time was very much in danger because the Civil War was around the corner. A tremendous amount of history in this hall. The most famous speech that some of you may know about was Lincoln's speech in 1860 here, the so-called right makes might speech, which launched him into his party nomination and the presidency. But many, many other great events, historically consequential events in this auditorium that make this in a perfect location. Sounds like that alarm itself goes back to the 19th century. That make this a most appropriate venue for this lecture on the Constitution. This was the site of the first convention of the women's suffragette movement. Susan B. Anthony worked in this building. This was the site of the first convention of the NAACP. This was the site of one of the first conferences, if not the first conference, of Native American tribal leaders in the 19th century while their people were being slaughtered on the plains. This was the venue for speeches by U.S. presidents and future presidents and former presidents. And so it is really a great honor for me to introduce this lecture series, the John Jay Iselin Memorial Lecture Series, which honors Jay Iselin, who was the 10th president of the Cooper Union. A South Carolina native, Jay Iselin was a descendant of both John Jay, who New Yorkers all know about, the first Chief Justice of the United States, and was also descendant of Benjamin Franklin. At Harvard, Jay Iselin was the managing editor of the Crimson. He was a Marshall Scholar at Cambridge, from which he earned a master's degree and later chair of the New York Marshall Committee. He earned a PhD in government from Harvard and went on to have a distinguished career in journalism, publishing, public television, and then here at Cooper Union as president. He served as national affairs editor of Newsweek and then as editor of trade books at Harper & Row. He continued his career in journalism as president of Channel 13 from 1973 to 1987, during which time he made the nation's largest public television station also the most innovative. And many of you are familiar with that era of public television, really a golden era in the development of Channel 13. Among the many programs the station originated and produced during his tenure were Great Performances, Live from Lincoln Center, the McNeil-Lehrer News Hour, Bill Moyer's Journal, and Nature. In 1988, Jay Iselin was appointed president of the Cooper Union. In his 12 years here, he completed a $50 million campaign, created new laboratories and endowed professorships, and really took the institution to a new level. This year's tribute to Jay Iselin is a series of 10 lectures on the United States Constitution delivered by Professor Burt Neuborne, who is the Inez Milholland Professor of Civil Liberties at NYU Law School. He's also the founding legal director of the Brennan Center for Justice. Professor Neuborne is a graduate of Cornell University and of Harvard Law School. We were just talking backstage about the those days of Harvard Law School and how difficult it was for women in those days. For 45 years, he has been one of the nation's foremost civil liberties lawyers, serving as the National Legal Director of the ACLU from 1981 to 86, Special Counsel to the now Legal Defense and Education Fund from 1990 to 96, member of the New York City Human Rights Commission, and a number of other important positions. He has argued before the Supreme Court, has litigated literally hundreds of important constitutional cases in the state and federal courts, and has challenged the constitutionality of the Vietnam War, pioneered the flag-burning cases, and worked on the Pentagon Papers case. So really a glorious history. He's a member of the American Academy of Arts and Sciences, has received the Distinguished Teaching Award from NYU, where he is a professor. I would also like to take this opportunity to acknowledge Lee Iselin, Jay Islin's wife, who is a lawyer in her own right, and we're delighted to have her here at a lecture series in honor of her husband, Jay Iselin. Please welcome our speaker tonight, who is going to really enlighten us about the Constitution, and let's get going. Thank you.
My thanks to all of you for coming out tonight on a stormy, rainy night. I appreciate it. A special thanks to Lee Iselin for making the lecture series possible in favor of her husband, Jay, whose leadership at public television during its golden era for 14 crucial years was a landmark, really, in the effort to achieve a genuinely well-informed public. And it's particularly appropriate, as President Barucha noted, that lectures on the United States Constitution be given in Jay Islin's memory, because Jay was the great, 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 great grandson of John Jay, the first Chief Justice of the United States. And thanks as well to President Barucha of Cooper Union for inviting me and for making it possible for me to speak in this storied venue, and for continuing the commitment to free public education that is one of the glories of the Cooper Union tradition. Now, as many of you know, and as President Barucha pointed out, I've divided my career between academic life at NYU and the practice of civil rights and civil liberties law. I estimate over the years that I have appeared in something like 500 constitutional cases, although I won't tell you what my batting average is. But I say that so that you understand that I make no pretense of Olympian neutrality. I am not speaking as some ivory tower academic in an effort to provide some value-neutral theory of the Constitution. I spent my life in the judicial trenches fighting for an expansive definition of constitutional rights, and even if I wanted to change, it's too late. So that as we go through the lecture series, please feel free to discount some of it on the grounds that you're hearing from someone who believes very deeply in the process, but who also can be very disappointed in the process when it fails to defend individual liberty. I hope in these 10 one-hour lectures to summarize for you the essence of the United States Constitution. Now, that is an ambition that borders on hubris. And I don't envision the lectures as ordinary law classes. If I wanted to teach a course in constitutional law, I could do it up the block at NYU Law School. Rather, I want to try to describe for the educated lay public my conception of the interaction between a group of black-robed bureaucrats that we call judges and the often ambiguous text of our three most precious political documents: the 1787 Constitution, the 1791 Bill of Rights, and the three great post-Civil War amendments that brought equality into the Constitution for the first time. This first lecture is a glorified reading lesson. I want to try to ask how these judges, how these black-robed bureaucrats should read those three precious texts. What is the right way to read the Constitution? Now, the United States Constitution is the longest-running charter of democracy and freedom that the world has ever known. We have every reason to be proud and grateful for our constitutional heritage. Now, as I'll discuss next week in Lecture 2 on the Constitution and democracy, our democracy has a great deal of warts, and people around the world are not so anxious to adopt the nuts and bolts of our democracy. I mean, who, for example, would want to select a way to elect a president, our electoral college, that makes it possible for the loser of the popular vote to become president? And we've done that 3 times in our history, 1876, 1888, and 2000, and we should pray that it never happens again. And who would set up a system of campaign financing that essentially delegates the running of the electoral process to 1% of the wealthy Americans and gives them vast, disproportionate political power? I mean, the rest of the world is not going to adopt that. But there is one thing, one attribute in American democracy that virtually every country around the world wants to copy. And that's the use of the courts to enforce a foundational document that sets forth the ground rules for democratic governance, and at the same time, the individual rights that the government must recognize against the political majority. I think it's not an exaggeration to say that the power of American courts to set aside the actions of the political branches when they violate the Constitution, which we usually call the power of judicial review, is the nation's most important contribution to the art of democratic governance. And indeed, since the Second World War, virtually every democracy in the world, whether an emerging democracy or an established democracy, has adopted some variant of the judicial review mechanism that was pioneered in the American Constitution. But ironically, the practice of judicial review in the United States faces a unique dilemma that the other courts around the world don't face. Every adoption of judicial review since the Second World War by these other democracies has taken place pursuant to a careful constitutional provision that provides for judicial review, or a legislative authorization that provides for judicial review, that gives the justices or the judges clear authorization to engage in the process and provides them with some guidance about how to go about doing it. Ironically, in the United States, there's a hole in the United States Constitution where the judicial review provision should be. The United States Constitution has not a single word explicitly giving the power of judicial review to the courts. In the absence of a grant of constitutional power, an explicit grant of constitutional power in the Constitution, where does the United States Supreme Court, the mothership of judicial review, the pioneer of judicial review, where does the United States Supreme Court get its power from? We're 209 years into our experiment with judicial review, and despite its role as the linchpin of our political system and the most admired aspect of American democracy, we still don't have a generally accepted explanation of where the Supreme Court gets its power from to strike down the activities of political and democratically elected branches. You know, it sometimes feels to me that talking about judicial review is like trying to talk to about babies, the origin of babies, to your 10-year-old kid. You want to say to the kid, the results are miraculous, but I don't want to talk about the process of creation. The process of creation is going to be shrouded in euphemism and mists. That's where the stork comes from. The stork brings us our babies when we don't want to talk about it to our kids. And you know what? In 2012 America, the stork brings us our constitutional rights because we don't have a real theory of it. Now, the stork story that we tell is that our rights are enshrined in this document called the Constitution, the text of the Constitution, and that all an unelected judge does when she decides a constitutional case is to open the Constitution and get a command. The founders speak to her and tell her what she's supposed to do in the case. And if you believe that story, then as an unelected judge, it's perfectly legitimate for her to strike down what an elected body does, because the superior democratic forum, the founders, the highest democratic institution that we have in our culture, is telling her to do it. And all she's doing is carrying out a hierarchically superior democratic command. And the woods are full of experts and constitutional scholars and judges who claim to have discovered a kind of constitutional Rosetta Stone that will tell the judge how to decipher the command that is coming from the founders so that she can get about her business about deciding constitutional cases and not be in violation of any theory of democracy, because she'll be acting as a super Democrat, enforcing the will of the founders against the lesser Democrats in the modern times. Now, none of the formulas for deciphering the constitutional text include the values of the justice. Indeed, conventional wisdom, which is consistent with the stork story, tells us that an unelected justice who would use her values to decide what the constitutional text means would be committing original sin against democracy. Imagine what would happen to a Supreme Court nominee if she told the Senate Judiciary Committee that she was going to consult her own values in deciding what the Constitution would do. She would be accused of democratic heresy, and she would be quickly shown the door. That's what happened to Robert Bork. In all recent nominees, who know better, cross their fingers and solemnly assure the senators that they will never use their values to decide constitutional cases. They dutifully promise, as Chief Justice Roberts did in 2005, that he'll just be an umpire, calling balls and strikes, but he won't use his own values in the cases. More recently, the more recent nominees have promised that they will just function to apply the law, but they will never make it. Or that they'll just be legal technocrats using their specialized legal skills to ferret out the actual meaning that the founders had. Much of the time, it's true. Much of the time, judges do function as simple agents of a command from someone else. When the text is clear, when there's a binding precedent, when there are consensus values in the society about how a case could come out, a judge is not using her own values. In those very large number of cases, a judge is deciding a case based on values that come from somewhere else, but not in a hard constitutional case. In a hard constitutional case, the stork story that we tell ourselves can't be true. In a hard constitutional case, where the text is ambiguous, there is no precedent, and values are in conflict, there is nothing else but the values of the justice that she can use to break the tie. If you think about it for a minute, a justice confronted with a hard constitutional case, the kind of case that I just mentioned, has 5 options. She can say, oh, this is a hard constitutional case, I'm not going to decide it. Silence is what I do in hard constitutional cases. And that there are some people who argue that. There are some people that say when there's no command, you're not allowed to act. The trouble with that, if you took it seriously, since so much of the Constitution is ambiguous and so much of our precedent is disputed, it would mean that the judge would have to throw out virtually all the cases that come to her. So the price of silence is a radical change in the American constitutional system. We could live without judicial review. Britain did it for years. France did it for years. But the price of silence would mean to reverse Marbury versus Madison and say that we won't use judges to enforce the Constitution anymore because the commands are too vague. The other thing the judge could do is say, no, I'm not going to do silence. I'm going to defer to the political majority. I won't impose my meaning if I'm not sure. I'll just let the political majority have its meaning. The problem with that is it eliminates the whole reason why we have a Constitution in the first place. The reason you have a Constitution in the first place is to check the political majority, to see that there is not a tyranny of the majority. If you let the majority tell you what the Constitution means in doubtful cases, the majority will always then say, it means what I want it to say, and we will eliminate the ability of a judge to be an effective check on majoritarian tyranny. So deference also virtually wipes out judicial review. The third way the judge can operate, and I'm afraid it happens sometimes, is you pick favorites. If you're not sure, you decide, consistently with your social class. You decide consistently with your race. You decide consistently with your religion. And that's terrible. That's awful. That's the worst way you can possibly set up a judicial situation. The fourth possibility, and there are judges who do this too, is random. Well, I ruled for the plaintiff last week, so I'm going to rule for the defendant this week, and hope that it all cancels out. Well, obviously, both being a biased judge and a random judge are absolutely unacceptable. The fifth one is values. The judge will say, I'll have to look inside. I'll have to check my values. And it'll be my values that I will use to give meaning to the ambiguous constitutional text in the relatively rare number of cases where I don't get any guidance from the language or from the precedent or from a consensus set of values. It seems to me that that is the only possible way that a justice can act. Now, don't get me wrong. I don't mean partisan values. I don't mean that a justice decides what advances the Republican Party agenda, what advances the narrow Democratic Party agenda. That would be institutionally destructive and scandalous for a justice to decide a case, to advance a narrow partisan agenda. I don't think they do it. Years of litigation, years of losing sometimes in very heartbreaking cases. I still never came away thinking that I was losing to a judge who was voting in a partisan way. Maybe a wrong way, but not a partisan way. I don't even think they did it in Bush v. Gore, which I'll talk about a lot next week. Bush v. Gore came very close to testing my constitutional faith, but I don't think they did it even there. Rather, I mean something much deeper. The values I'm talking about, that the justices must use to break ties in close constitutional cases, are the core values on which our society is based. Values like autonomy, individual autonomy, equality, self-government, just desserts, stability, security, regularity, procedural fairness, and the capacity for change. Every justice, every American embraces all of those values. But in law, as in life, there will be settings where you can't have them all, where some of the values are in conflict, where you have to build a hierarchy of values to tell you which set of values is more important. Each person, including each justice, because each justice is a human being, we have our own hierarchy of values, held with different degrees of intensity. Often the hierarchy of values is intuitive, often it's not conscious. But they're there and they drive our daily life. But the values are not randomly distributed, and here's where I start getting radical. The values are not randomly distributed among the population or the justices. You don't just get up in the morning and the hierarchy of values drops on you. In today's politically polarized world, people do not gravitate randomly to a hierarchy of values or to a political party. They tend to affiliate with the political party whose policies and rhetoric seem most comfortable with their own intuitive sense of their own hierarchy of values. And the justices of the Supreme Court are no exception. So that I think political party membership Republican and Democrat, in the modern era, might not have been true years ago when the parties had no fixed ideological base. But in the modern era, membership in the Republican and Democratic Party is a pretty good proxy for figuring out what the value hierarchy of the individual is, whether it's an ordinary citizen or a justice of the Supreme Court. At the risk of oversimplification, Republicans, including Republican justices, tend to value autonomy, stability, and security higher than equality, capacity for change, or participation in the democratic process. It's not that they're not in favor of all of those values, they are. But when they're forced to choose, they build a ladder, a hierarchical ladder, in which autonomy trumps equality. The Democratic justices go the other way. They go the other way. And you would almost expect it because of the ability of the party to stand as a proxy. So neither is right, neither is wrong. They're matters of free choice in a free society. And if I'm right in saying that a justice's values inevitably have to play a role in deciding close cases, and if I'm right in asserting that those values will tend to correlate with the justice's political affiliation, the decision in a hard constitutional case will depend not on some command from the founders, but on which party controls a majority on the Supreme Court. And over time, two constitutions will emerge, like a coral reef. A democratic constitution, forged out of value choices in hard cases made by democratic justices when they're in the ascendancy, and a Republican constitution, forged by Republican majorities on the Supreme Court when they have to use their values to break ties. Now this comes close to heresy, because what I'm urging today is that there is a very strong, the line between politics and constitutional judging in a hard constitutional case is an imaginary line. During the 1960s, the Democrats enjoyed a comfortable majority on the Supreme Court, 7-2 sometimes and 8-1. This was the legacy of being in power all the years when FDR was reelected, when Truman was elected, when Kennedy was elected. You had a democratic court, and the law that came out of that court was democratic constitutional law, most intensely during the really revolutionary period of the 1960s, when so much of American law was remade by the Warren Court, who Warren, of course, ironically was a Republican, but I've adopted him as an honorary Democrat because of his values. Maybe the most important political event of the 20th century took place in 1968, when LBJ, the master politician, botched the succession when Warren wanted to resign. Warren had been Chief Justice for 15 years, and he called LBJ because he wanted to block Nixon from having the power to appoint the new Chief Justice. This is 1968, and we're coming to a very, very close election. So he says to LBJ, I want to quit, but I want to give you a chance to appoint my successor. So LBJ says, I appreciate this. This is what I'm going to do. You write me a resignation letter saying that you resign effective on the appointment of your successor, and I'll start getting about the appointment of the successor. So LBJ goes to Abe Fortas, who is a Associate Justice on the Supreme Court, and he says to Fortas, how'd you like to be Chief Justice? And Fortas says, of course I'd like that. That then opens up a vacancy, which LBJ is going to give to Homer Thornberry, a Democratic congressman from Texas, who was a very close friend. And if it works, it solidifies and cements a Democratic majority on the Supreme Court of 7-2 that would have lasted throughout the 20th century. We would have had a democratic constitution throughout the 20th century if this had worked. It came apart because Abe Fortas, first during the confirmation hearings, it turns out that Abe Fortas had taken a job teaching at American University that was paying him 40% of his salary, and that the money was funded by large corporations who were appearing before the Supreme Court. So everybody said, no, I don't want this guy as Chief Justice. He's the first judicial nominee to be filibustered. They filibustered the nomination, and eventually LBJ had to withdraw it when he was unable to get 67 votes for a cloture vote. Now, in fairness, the most votes he had was 43. So he withdrew Fortas's nomination, but that still left Warren as Chief Justice and Fortas as Associate Justice. Nixon then gets elected president, and in 1969, it turns out that Fortas had a retainer agreement with a financier named Lewis Wolfson, who was a shadowy figure who was always in and out of trouble with the regulatory agencies. And the retainer was that Wolfson agreed to pay Fortas $20,000 a year, even when he was on the Supreme Court, in return for legal advice. When Warren heard that, he called Fortas up and said, you have to resign. You can't sit as a Supreme Court justice after this. So Fortas resigned. Warren then resigned at the end of the term in 1969. Nixon is elected, gets four appointees during his term, and flips the Supreme Court in 1971 and 72 to 5-4 Republican, which has stayed Republican for the rest of the century, sometimes by votes of 8-1 to 7-2. And the Constitution that has emerged over those years is 10 years worth of a democratic Constitution, 40 years worth of a Republican Constitution, and the consensus Constitution, which is the stuff about precedent, ambiguity, a strong textual meaning without ambiguity, and shared values. And so what we live in a world with three constitutions revolving around each other. The Republican Constitution forged in the last 40 years by the Republican majority, the Democratic Constitution forged in the 60s by the Democrats, which is locked into power by the consensus Constitution that says that you don't overturn precedent. So we live with those constitutions, and every sophisticated constitutional lawyer knows it. So why don't we admit that values play a role? Why do we keep telling ourselves the stork story when it's so clear that values are playing a role in the Supreme Court decisions? And I believe the answer lies in the difficulty that I mentioned at the very beginning of this talk, and that's that the Constitution doesn't have explicit authorization for judicial review. So instead of a constitutional provision, all we have is John Marshall telling us the stork story in Marbury versus Madison, which is the first case that exercised judicial review in 1803. What Marshall said to us is, look, I'm just a passive judge. All I do is put the Constitution next to the statute, and if the statute violates the Constitution, the founders are telling me something, I have to listen to them. And the hypothetical he gave to prove it was that the treason clause of the Constitution requires us 2 witnesses before you can convict somebody of treason. He said, what if Congress passed a statute saying that I could convict somebody on 1 witness? I would put that statute next to the treason clause. It would be horrible for me to enforce it. And of course he's right, because those are cases that are train wreck cases, where the Constitution is on a collision course with what the majoritarian bodies are doing. And there's a clear violation between unambiguous text and what the majority of the political groups are doing. Train wreck cases are explained beautifully by the stork story. The dirty little secret of American constitutional law is that there are very, very few train wreck cases. Marbury versus Madison itself was not a train wreck case. The Article 3 provisions that Marshall was construing are incredibly ambiguous, and the consensus today is that he probably got it wrong. He probably read it wrong. The stork story just doesn't work in any case that's not a train wreck. So if it doesn't work, and if Marshall read it wrong, and if the dirty little secret of American constitutional law is that the Supreme Court just plows ahead, it does not differentiate between train wreck cases, where there's a clear intellectual justification for what they do, and non-train wreck cases. Instead, they have to pretend that in non-train wreck cases, founders are talking to them. In the night, maybe when they go to sleep, but founders are talking to them, giving them a clear answer as to what the Constitution requires. Now, if you lived through the Warren years and you watched the Supreme Court function, and if you've lost as many cases as I have under the Republican Constitution and watched it function, you have no doubt that that's not the true story. That the last time I looked, founders do not whisper to the justices before they go to sleep. That the justices are using their values, appropriately so, I'm going to argue in a minute, because I don't know what else they could do, to shape the Constitution. But in recent years, because the gulf between what the court does and the Stork story is so great, a series of repairmen have descended onto Marshall's ideas and tried to repair them. Usually they're right-handed repairmen trying to repair from the right. First one are literalists. They say, I can make everything a train wreck. I can make everything a train wreck. You just literally read the Constitution, you put it against the statute. If they collide, you've got a train wreck. That would be great in the treason cases. That's exactly what Marshall did. He said, it's two witnesses, one witness, I've got a train wreck. The trouble is, how do you read literally unreasonable search and seizure? What's the literal reading of cruel and unusual punishment? What's the literal reading of establishment of religion or free exercise of religion? Think about how you would literally read the First Amendment, which says Congress shall make no law abridging the freedom of speech. First of all, it says Congress. You want to read it literally so it doesn't cover the president, so it doesn't cover the police, it doesn't cover the military? Of course not. We read it to cover everybody. Then it says no law. That looks like it's a good candidate for a literal reading. And if it said no law abridging speech, then I could apply it literally. But that would mean that blackmail is protected, threats would be protected, the mere fact that you spoke would be protected. And everybody knows that can't be right. And the founders knew it couldn't be right. And so what they put into the Constitution was abridging the freedom of speech. The freedom of speech has no literal meaning. It's a vessel, it's a concept into which we pour meaning by thinking about what we want the freedom of speech to mean. And so something as central as the First Amendment can't be read literally. And then you go on to say, what does equal protection of the laws mean? It turns out that even the literalists agree that most of the Constitution that matters doesn't have a literal meaning. So that repair effort fails. The second repair effort, though, is more dramatic and more enthusiastically supported, and that's originalism. Literalists say, okay, I give up on literalism, but I have a safety net. And my safety net is originalism. If it's an ambiguous clause in the Constitution, why can't I go back and figure out what the original founder wanted it to mean as a historical fact? I'll go back and discover it as a historical fact, and that's the command. I will then have a command. I may not like the command, but that's the command that tells me what to do. And so originalism is a search for what would be a single right answer coming out of history about what the original founders wanted it to mean. There are three problems with that. The first one is, are we sure that we want to lock the Constitution in the 21st century into a social world that accepted slavery, that oppressed women, that allowed only the rich to vote, and that had no serious protection of free speech? I mean, why would we want to take our Constitution and drop it back into that intellectual milieu so that we had to live in the 21st century as though we were still living in the 18th or 19th? I think that first one is very debatable. The second one is, whose intent counts? Is it Madison, who wrote the Constitution? Is it the people in the Philadelphia Convention who voted to accept it? Is it the voters in the various colonies, old colonies, new states, who voted to ratify? Is it some other group of the general public, whoever that means? It certainly doesn't mean people of color or women. What did they think it meant? The truth is, if you don't know whose intent you're looking for, then it's awfully hard to find it. And then finally, even if you give them the first two, it turns out when you do serious history and you really look back to the founding generation, they were as confused and as divided as we are today. And when you look back, you see some people wanted it to mean this, some people wanted it to mean that, and you wind up with a historical tie. It happens in case after case. I can't tell you how many 5-4 decisions there are where the justices buy up all the history books in circulation, spend years poring over them, and then divide 5-4 about what the history is, because it's a tie. As it always is in hard constitutional questions, if you're intellectually honest. Now, Justice Scalia says, yeah, I know that. I know that it is often difficult to get history right and that often we disagree. But Scalia says that's better than disagreeing over politics, over values. He said, I would rather disagree over history, which is non-political and technical, than I would over values. So originalism is great because even if it doesn't deliver a single right answer all the time, it changes the debate from a debate over values to a debate over history. That would be a brilliant response if it didn't always just happen that the justices find that the history happens to support their values. The rascally founders, when the justices ask them, the rascally founders tell the justices what they think they want to hear. And there isn't, I can't think of a case in which a hard historical tie has been broken contrary to the values of the majority of the court. So what you have is a smokescreen where they claim to be talking about history, but they're using values to finally resolve the case. It's like, remember, those of you who've seen Guys and Dolls, there's a great scene in Guys and Dolls where Big Julie is shooting crap in the sewers. And he's losing. Big Julie is a crook from Chicago. He's losing. And he turns to Nathan Detroit, who's running the game, and he says, Nathan, I want new dice. Nathan says to Big Julie, that's fair. If you're on a losing streak, you can change the dice. Big Julie says, no, I want to use my dice. And Nathan says, okay, Big Julie, I'm worried about your gun. We'll use your dice. So Big Julie gives him the dice, and Nathan looks at the dice. And he says, Big Julie, there are no numbers on this dice. Big Julie says, I remember where the numbers were. Anthony and Scalia couldn't have put it better in describing what they do with history. So originalism doesn't work. Then there's a third one, my idol, William Brennan, the living Constitution. I patterned my career on trying to advance Brennan's values. Brennan's idea of the living Constitution was to take a reasonable founder and rotate the reasonable founder 200 years into the future, sit the reasonable founder down at his desk, and then ask the reasonable founder, what do you want the Constitution to mean today? And you know what? It's amazing. The reasonable founder never disagreed with William Brennan. It was remarkable how they just got along so beautifully. And if Anthony Scalia's conception of originalism is Guys and Dolls, Bill Brennan's conception of nocturnal conversations with ghostly founders is Monty Python. As a way of generating a single right answer. Don't get me wrong, he generated fabulous law, but it wasn't because the founders were telling him. It was because it was coming out of Bill Brennan's values. So the living constitutionalism doesn't work. There are two others. There's purposivism, to try to say, okay, I don't want to know exactly what they meant, but what was their general purpose? And then what I'll do is construe the Constitution in the modern world to advance that general purpose. That's what most judges do today. It's what a majority of the Supreme Court does today. It's what most judges do. It's what Bill Brennan did if you take away the nocturnal conversations. The trouble with it is it also generates excellent constitutional law sometimes, but people will disagree with what the general purpose is. But more importantly, they will dramatically disagree with how to advance the general purpose in the modern era. And so although purposivism is a lovely idea, it doesn't solve the one right answer problem. It doesn't give you a single right answer. So the second dirty secret of American constitutional law is that 50 years of effort to shore up the stork story and make it work by finding commands coming out of the Constitution that don't require values have failed. And they just failed utterly. They failed when the left tried it with Brennan. They failed when the right tries it with Scalia. I think it's time to let the justices' values out of the closet. I think, having now lived with a almost hypocritical refusal to acknowledge that the justices are using values, and then expending enormous, whole forests have been felled, entire law schools have received tenure on the basis of talking about whether these theories really do fix the Constitution. In the end, they all fail. In the end, they all fail. The truth is, we don't need Marshall's Stork story to justify judicial review. We never did, if only we had the courage to announce it. In fact, using values to decide hard constitutional cases is not undemocratic. It is a form of indirect democracy that is very similar to the indirect democracy we use in lots of other areas. In the modern state, with a complicated government and a large administrative hierarchy, what we wind up doing is we elect a president who shares our values. The president then appoints technocrats, somebody to head the Securities and Exchange Commission, somebody to be on the Federal Reserve Board, somebody to head the Environmental Protection Agency. These are people with expertise in those areas who will be expected to use that expertise consistently with the value hierarchy of the president in appointing them. But they're insulated from day-to-day political pressures. They're supposed to be. Many of them now serve terms that are as long as 15 years, and that cross over administration from administration. So a president can be elected and have members of the Securities and Exchange Commission who have values very different than his, and there's no way he can get rid of them. Because we have because we believe that indirect democracy works well. When you elect somebody, that person then appoints an official to carry out the activities, and you insulate that person from political pressure until the term runs out. And you hope you get the best possible activity. Think for a minute. That's what judges are. That's why I called them at the beginning of the talk black road bureaucrats. A judge, a justice of the Supreme Court or a judge of the federal courts, is nominated by a president who has been elected by the people, who shares the value of the political majority. That president then appoints judges and justices with the advice and consent of the Senate, who are also elected. And you have to run, at the end of the process, the court is populated by people who share the values of the appointing officials, of the president and of the majority of the Senate that has to confirm them. And over time, those justices, when they get a hard constitutional case. Now, remember, I'm not saying all cases are like this. I'm saying every term there are about 10 or 15 that are like that. Most of the cases are cases that fall within the consensus constitution where the text and the precedent take care of it. But the hard cases, the 10 or 15 cases each term that don't have text and don't have precedent, the justices are using their values. And if the people don't like the Constitution that is emerging from those justices, if they don't like the decisions in those cases, it's not because the founders did something that we can't change. There isn't some voice from the darkness giving the justices the command that we as individual people can't change. We can change the Constitution. You change the Constitution by changing the nature of the agent that populates the court. Just as FDR and Truman and Kennedy populated the courts for a democratic constitution, and just as Nixon populated the courts for a Republican constitution, we can populate the courts for whatever constitution our values call for, Republican or Democratic. Ironically, the real obstacle to popular control over what the Constitution means is the refusal of the justices to acknowledge that they're using values, and the refusal of the experts to move away from the Stork story. The truth is, if we told the truth about what the justices actually did, and read and opened up to the fact that there are values, we would trigger a democratic, indirect democratic process that is perfectly justifiable and that doesn't need a stork story. And so, I believe every presidential election is a rolling constitutional convention where the voters place within, give the power to repopulate the court. And by the way, repopulating the court happens. On average, a new justice is appointed every 22 months. So you repopulate the courts over time. To repopulate the courts with people of your own value orientation. And in this election, 2012, and probably the election of 2016. Those two elections are the single most important elections in terms of shaping the meaning of the Supreme Court since the re-election of FDR in 1936 and the election of Richard Nixon in 1968. The outcome of this presidential election, perhaps, but certainly the next two, will shape the Constitution for the rest of the 21st century. And so the stakes in the election process are not simply the hugely important stakes of economic policy and different visions of the role of government. You are, in a true sense, founders. And the question is, what kind of Constitution will you found? Thank you. Thank you. Thank you. That's very kind. I mean, especially since you came out on a rainy night. People who have to leave should feel free to leave at this point. But if there are any of you who would like to ask questions, I would be delighted to try to respond to them. There's a mechanism for that. Are there mics for the questions? Where are the mics? I can't see them. Oh, the mics are up front. Would you do me a favor? Come up to the mic. Ask your question at the mic, because otherwise it won't be caught by the audio and the video aspects of this. Thank you. So, and do me a favor, make them questions, not speeches. That, by the way, is like talking, that's King Canute telling the tide not to come in.
Hello? Yeah. There seems to be a contradiction between the United States Constitution and American law. And my question to you is, how do we resolve that? For instance, the Fifth Amendment of the United States Constitution prohibits the state from compelling a citizen to testify against, to bear witness against himself. I think I have
to incriminate himself.
That's correct.
Right, you have it right.
So how is it possible for prosecutors to engage in this process of plea bargaining in which a defendant is compelled to plead guilty to charges so that he or she can get a lesser sentence? How does that work? You're talking about that train wreck and that collision between the Constitution and the law.
You raise a great question. The question is, how does the current process, 98% of all criminal prosecutions in the United States don't go to trial. They are resolved by pleas of guilty. So that the question is, doesn't that process in some sense violate, if not the letter, the spirit of the Fifth Amendment that says you can't compel someone to incriminate themselves? Don't you incriminate yourself when you plea bargain? The theoretical answer is the plea bargain is voluntary. The theoretical answer is, you want to go to trial? Go to trial. No one can make you testify at the trial. So if you want to go to trial, go to trial. And take your chances about whether you win or lose. If you don't want to go to trial, here's the deal. Here's the bargain. Plead guilty and this will be your sentence. My sense is that probably, I'm jumping ahead. The seventh lecture is a lecture in criminal procedure. And we'll talk about a lot of this at that point. But my sense is it doesn't violate the Fifth Amendment. Plea bargaining doesn't violate the Fifth Amendment. It may violate something else, very immoral. It violates something deeply moral in the system, in that poor people probably don't have the resources to go to trial in an effective way. So they're forced to plead, because if they go to trial, they can't afford the kinds of huge defense operations that very wealthy securities fraud people or someone like that can put in. So they're forced to plead more often than rich people. But that's a different issue. That's an issue of the equality of the system, which I hope to take up as well. Thank you.
Thank you.
Want to do it from here?
Could you?
Let it never be said that I don't go from left to right.
Could you comment on how the process in the common law of making decisions and getting change dovetails with your process? And in particular, I believe there was one Supreme Court case before Marbury that overturned a state law, and that there were cases in the common law that had overturned what
Sure.
might be deemed a constitution.
Sure. President Barucha, did you know that lawyers were let in here? This guy knows too much. I was promised that I wouldn't have to lecture before lawyers. It's a great
Well, I
question.
went to NYU.
No. It's a great question. The short answer is that common law, where judges just make law because there is no statute and there's nothing else, and you just go into court and the judge decides the case and therefore creates common law. Common law doesn't usually trump political majorities. If there's a statute, you can't make the common law. The statute controls, not the common law. And in the absence of a constitutional provision, you can't use common law to overturn a state statute. You have to use the Constitution. Now, it may be that in the very murky years before Marbury, during the late 18th century, there may have been some state judges who were experimenting with the use of the common law as a constitutional device. But if it existed in the 18th century, it died very quickly. Marbury killed it. And the only way that you have setting aside the majority now is if you can invoke the Constitution.
I'm going to ask a very bare bones question because you'll fill it out better than I can. So in the Affordable Health Care decision, Justice Roberts' values were clearly on the table, but he decided not to go with his real value on the Commerce Clause, but to disguise the decision under the Taxing Clause. And is that because he, maybe you don't agree with that, but is that because he wanted to preserve a value for the next case and the next case under his sort of Chief Justice role?
Well, I hate to psychoanalyze him on it, but I must say, I never saw an umpire do as many somersaults as John Roberts did in the healthcare case. If that's what umpires are, then I'm not playing baseball anymore. But the Roberts opinion in that case, which I'll talk about when we do federalism, because it's a Commerce Clause case and it's an allocation of power between the state and the federal courts. I think it's the 8th lecture. But if I survive, but the Roberts opinion, I think, comes very close, and I'll just take a second to tell you that I think it's very close to what Marshall did in Marbury, because Marbury was all about an effort to embarrass Jefferson by forcing Jefferson to give a commission to a Federalist, and Jefferson allegedly was acting unlawfully in refusing to give the commission. So Marshall writes this long opinion saying Jefferson should be ashamed of himself. In this country, the law triumphs over everything. It is awful that he won't give him the commission. So poor Marbury stands up now, drunk on the rule of law, and holds out his hands for the commission. And then Marshall hits him over the head with a rolled-up copy of the Constitution and says, sorry, I can't do anything for you because Congress's statute giving me power is unconstitutional. So what he did is he gave all the rhetoric to his friends and the reality to Jefferson because he was afraid of what Jefferson would do. There's something very similar in the healthcare opinion. Roberts' opinion gives the two red meat issues that the right really care about: the ability to regulate affirmatively under the Commerce Clause and the ability of Congress to blackmail the states into entering programs by threatening to pull money away from them in other programs. And Roberts goes down the line with the 4 Republican justices to create a 5 Republican justice majority in that area. So he gives them the red meat issues. He gives them all the intellectual issues that they wanted, and then he yanks the rug out from under them by recognizing the power as power under the tax clause, which means that Obama can't do anything about it either. Obama is sort of has to say, "Oh, what a great opinion! I love this." He can't come back and attack the court. And in some sense, I think the Chief Justice was preserving the institutional legitimacy of the court, because if they'd knocked the Obama bill down, a political firestorm would have erupted, and the campaign would be a campaign where Obama was running against the court. And he might have won, he might have lost, but that couldn't do the court any good. And my sense is that Roberts was institutionally protecting the court by doing a little bit of umpire acrobatics. Yeah.
In your talk, there was a strong dichotomy. You make a big distinction between the easy cases and the hard constitutional cases, the train wreck cases, the Stork cases on the one hand, and the tough cases on the other hand. And it seems like the values are appropriately used in the tough constitutional cases, not really necessary in the easy cases. If that's the case, what's happening in the easy cases? Is it that you can really have a text-based interpretation of the Constitution that's either relying on the words themselves or the original intent of the framers in those easy cases? If you can do that in the easy cases, if that's really the exercise for the easy cases, why can't you do the same thing in the hard cases? And it's just harder. It's just harder to do them. And then, assuming that that you can do them there, why shouldn't you? The argument that you made against doing them there is that the way it's done is intellectually dishonest.
Well, the way it's done is intellectually dishonest because it turns out that it can't be done. I mean, the reason that the distinction between an easy case and a hard case in an originalism case is if you do the research and it's pretty clear what the history is, then it's an easy case. The history compels you. And all 9 justices accept that. The problem is when you have a 5-4 case where 9 intellectually strong people with law clerks, some of whom I've trained, actually do the historical research and say, well, we can't figure it out. There's a huge argument about one or the other. It's not an easy case anymore. It becomes a hard case because who's to say the 5 is right and the 4 is wrong? There's a great line from Jackson. Many of you know it. Robert Jackson, who was a justice of the Supreme Court, once said, look, the Supreme Court is not last because it's always right. He said it's right because it's always last. And sure, the 5 have got 5 votes, and that makes them right. But it makes them right only because they had a bigger club than the guys with the 4 votes. It doesn't create a kind of certainty that you're looking for. In easy case, the certainty is there. If the certainty is there, I agree with you. But that's what makes it an easy case. In the hard case, where the certainty is not there, and you have to break a tie, you can honestly believe what you're doing is relying on history. But when it's 5-4, what's pushing you, whether you admit it to yourself, whether you admit it openly, is a value. Because values help us decide what we believe. And they often operate unconsciously in the back of a justice's mind. I don't think that they necessarily are lying when they say they're not using values. But I can't imagine how they can claim year after year when there's a Republican majority and a Democratic majority, and they're both 5-4 and they're both looking at hard cases, that values aren't the thing that finally breaks the tie. It can't. Mathematics tells you that a random allocation of these cases could not come up with Republicans and Democrats being on the different sides so often unless there was something operating in the background that makes it different for a Republican or different for a Democrat. Now, please don't misunderstand me. They're not wrong. The Republican justices are not wrong when they do it. I don't know how else they can do it, and unless they want to be silent or unless they always want to defer. So Fritz?
So finding your...
One of my favorite colleagues, Fritz Schwartz.
and
A
finding...
lawyer, by the way.
Finding your logic and your presentation completely convincing, and your conclusion, which is that elections are actually a new and constantly every 4 years constitutional convention, I wonder if you don't have to take your suggestion actually one step further, because as justices live longer, and presidents recognize they live longer and recognize that the justices are going to split depending on who appointed them.
Yeah, and when they appoint them younger.
And they're going to appoint them younger and younger. Don't we need to have term limits for justices to allow the democratic process to really ultimately work?
Yeah, I actually would be very sympathetic with something like that. I think you're right, Fritz. I cheated when I told you that they repopulated a Supreme Court every 22 months. That is the statistic. But it's the statistic that works for 215 years. The more recent statistics are that the justices stay in office longer. If you were selling life insurance, the first person that you want to sell a life insurance policy would be a Supreme Court justice. They live a long time. They have good lives, and it's not. Maybe we do need some sort of renewal process. That's what Roosevelt wanted in '37 with the court packing plan. He wanted to appoint a new justice for every justice who was over 65, so that there would be a constant. You don't throw the justices out, but you renew the court from underneath by appointing new justices as the justices get older. It was seen, I think correctly, as a partisan political attack on the court, and it died. But there could be serious arguments. In most state courts, you have a retirement. Judges have to retire at 70, or at 72, or at 75. That's not a bad idea. That's not a bad idea.
So I think most textualists or originalists would agree that Marbury versus Madison wasn't a textual decision. So how do textualists even get to the point of judicial review?
Well, I think a textualist would, it's the right-wing repairman. The textualist will say, I can fix it. Yeah, I agree that Marbury, because the text of Article 3 was so ambiguous, it's awfully hard to make it into a convincing textualist case. But what they would say is, give me a minute, I'll fix it. I'll have a theory of literalism, or I'll have mostly a theory of originalism. What they would have said that Marshall should have done is go back and figure out originally what they wanted Article 3 to mean. One of the reasons that Marbury is so wrong as a decision is that it's decided in 1803. The clauses are put into effect in 1787. The statute is passed in 1789 by people in Congress who were actually members of the Constitutional Convention. They knew what Article 3 meant, and how many years later, 1803, Marshall says, I know better. I know better. And it's if you really believe that originalism works, it does save a lot of Marshall's theory. So I'm afraid I'm going to have, Richard Emery is going to be able to get me privately. He always asks me good questions, but I'm afraid that I've overstayed my welcome in the hall. Thank you all for coming.